clip shows?
You know, I think the clip shows that the camera is zooming in the first clip on Mr. Robinson's lips as he is trying to communicate with me sitting next to him.
Thank you.
If I may reapproach with the second video you're on.
Yes.
This one is 5 seconds, Your Honor.
It looks like, okay.
And Your Honor, the second video is a clip from a court TV posting showing Mr. Robinson's lips moving as he's attempting to speak to Ms. Nestler. And Your Honor, one last thing I'd like to add if I could, which is I think the court very correctly and very cautiously admonished the cameraman about your December 23rd order before this hearing began. And he said he understood the order, and I think the order is very clear as to this lip reader provision. And I can elaborate further why it's damaging, but I think it's obvious to the court if the media is allowed to interpret the conversations between counsel and his lawyer, it creates all sorts of problems in terms of Mr. Robinson's right to a fair trial.
Thank you, Mr. Burt.
Thank you.
And just one more question. I apologize. Just for the benefit of the record, from your position, citing to the standing decorum order, the violation itself, so we can connect it all from your arguments.
Yes, Your Honor. I forget the paragraph, but there is a paragraph in the court's latest December 23rd decorum order.
It's paragraph 48.
48. And it's been a feature of every decorum order. I think we're on the third one. But from the start, the court has prohibited zoom-ins to allow lip readers to interpret what's being said between counsel and the defendant.
And finally, I think you led with this in regards to the sanctions being requested. You cited to the court sanctions, and then there was a second one referring to, and I want to make sure I wrote it down right, because
Sure.
Something along the lines of not showing Mr. Robinson at all. I want to make sure I understood that request.
Sure. The request was either to exclude the cameras for purposes of this hearing in its entirety because of the violation and because we can't be assured that the cameraman's going to comply with the court's order. The second request is if the court is not going to exclude the cameras, then it should, at the very least, order the cameraman not to shoot any footage of Mr. Robinson, that the camera should be focused on the court and the witnesses if the court permits that, but it should not be zooming in on Mr. Robinson. His demeanor, his conversations with his lawyers have nothing to do with the newsworthiness of this case. And what it's allowing is very prejudicial information to be leaked to the public through these lip readers and body language interpreters, and it's creating massive prejudicial publicity for us. So that's the request.
Thank you, Mr. Burt.
Thank you.
I'll hear from other parties if they wish to be heard.
Yes, Your Honor. Michael Judd on behalf of the media entities. I want to take the court back to that specific paragraph of the decorum order because I do want to make sure we're on the same page about this. It's the second sentence of paragraph 48 of the decorum order that I understand is at issue here. It does say no visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel, at counsel tables, or bench conferences with the judge. The zoom-in language that you have heard referred to previously doesn't fall in that sentence. The zoom-in language comes in the next sentence, which says no one may zoom in on anything on counsel's table or the bench to identify any writings. So those are two separate things. The first that we learned about this was during the break. I briefly reviewed the two videos that the court has reviewed. I understand that those were 9 seconds and 5 seconds long. I identified the provision of the decorum order that I believe applied here, spoke to the pool cameraman about that, ensured that the rule about capturing conversations involving counsel at counsel's table or at the bench so that they may be decipherable by lip readers was an important provision in the court's decorum order, that it should be followed. I understand that the cameraman understands that rule, that any capture of those conversations was inadvertent. I understand the concerns raised by defense in this case about potential prejudicial effect of something that is intended to capture conversations. I don't believe that that's what occurred in this case. I believe that the court's order should be understood and applied as written and done so strictly. But I don't believe that there's been a violation here. We've been now on the record for 3 hours. I believe that the total length of the two videos that were shown to the court were 14 seconds long. Whether or not either of those conversations rises to the level of capturing the movement of somebody's lips so that it can be decipherable from a lip reader, I'm not in a position to judge. But I can assure the court that the media is aware of that provision, of defense's concern about the potential violation of that order, and that they will take that seriously. That's already been raised, already been discussed. As far as the remedy sought here, I think that excluding all cameras from the courtroom for this important part of this important proceeding would be broader than any sort of remedy would be necessary here, as would the direction that the cameras not show Mr. Robinson in any way. I understand that potentially any shot on a still camera, on a video camera, of a defendant in a criminal case could potentially be twisted or used by some to try to impute some sort of thought or some sort of idea. But I don't believe there's anything in the court's rules. I don't believe there's anything in the ruling so far to date that suggests that the way to address that kind of concern is to say that a defendant, a critical figure in a case like this, and one that the decorum order clearly allows to be photographed and videoed, be kept off camera altogether. The media continues to take this seriously. Before every single hearing, we speak about the decorum order and what it requires. We recognize the importance of doing it and that there can be consequences if that's not kept. The media understands and hears that and do not believe that any further reprimand or any sort of further exclusion is necessary here.
Thank you. But before I turn to you, I want to turn to the stage. I want to give all parties an opportunity, and then that allows you to respond to whatever they say.
Your Honor, we have nothing to add. We'll submit the issue.
All right, Mr. Burt.
Judge, the problem with that explanation, that's the same thing they said last time on December 11th. And on December 11th, there was a same violation. Lip reader. I can pull up for the court what the electronic media did with the prior violation. They hired a lip reader. The lip reader purported to derive a confession from the incident, and they posted that. It's still up there. So it's great that they apologize, but once this kind of damage is done, it is irreparable. And we can't continuously have violations where the media gets up and does this mea culpa, and they just continue to do the same thing. And I point out to the court, this is the same pattern that happened in the Korberger case that's discussed in the motion we filed today. And eventually the court there had to order that all coverage of Mr. Korberger's face was prohibited. And we attached that order to the motion that was just filed with the court. And I understand the media's desire for dramatic coverage. I understand how they want to incriminate Mr. Robinson. But that process is supposed to happen in a trial, not in the media. And it's a serious violation. It's one that the court should not just blink away and say, I accept the apology, especially after the court was so clear this morning. Calling the cameraman up, asking if he had read the December 23rd order, and his response was, I'm good to go. Meaning he had read it, and presumably he read that provision about zooming in on lips. There's no excuse for it. The court should take some action.
Thank you, Mr. Burt.
Thank you.
Anything further from any of the parties before this court makes a ruling on this issue that's before it.
No.
I just want to make one note, Your Honor. Those clips that I showed you are just small portions of much longer footage that was available in the live stream. That was just what we needed to compartmentalize to get it to Your Honor, but it was a much more extensive period of time.
All right. All right, I appreciate this being brought promptly to the court's attention. This is an important issue, and the court takes it very seriously. As it relates to today, well, first, I did put on the record very clearly that there would be potential consequences for any violation of the court's December 23rd, 2025 standing decorum order. For the first part, well, and I've also had a chance to view the two clips that was presented. It was shown to all parties. The first appeared to show an attorney and Mr. Robinson speaking for about 9 seconds is what my memory tells me, reminds me. The second clip was for about 5 seconds. I believe it was from a slightly different angle, but it also captured that. And in both instances, I could see Mr. Robinson's lips moving, and I don't remember about the second clip, but I believe in the first clip it also showed counsel's lips moving, but notwithstanding, that was in place. I also refer to the statement made by the counsel for the news media, and going to it is paragraph 48, and I will read it in its entirety. No audio recording is permitted of the conference involving counsel at counsel's tables or during bench conferences with the judge. No visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel at counsel's table or bench conferences with the judge. No one may zoom in on anything on counsel's tables or the bench to identify any writings. Now, in regards to the zooming, I know there was a representation, and it's easy to, as you're reading, to kind of combine it, but I'm not finding that zooming in relates to the lip reader portion, but that's not material. I do find that, and I'm not a lip reader, so I don't know what the standard is for lip reading, but I do note that 9 seconds in that first clip, one could see his lips moving, and it is a significant time for, as it relates to this particular issue. It wasn't a passing shot. It was focused on these two persons, and so I find that the decorum order, as it relates to section paragraph 48, as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader, I find that has been violated. In regards to the second clip, 5 seconds, where it shows Mr. Robinson and I believe one of counsel, that I was able to view Mr. Robinson's lips moving. It wasn't a passing shot that it just so happened to capture. It was focused on them. I find that is a violation of paragraph 48 as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader. Turning to the next section, finding that the violations have been shown as the court has reviewed the purported evidence of these two violations, I turn to the sanctions. Previously, I stated that under Utah Code Section 78B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. I find that applying this sanction would be disproportionate to what the conduct was in those two clips. And the court notes that it is the court's discretion on whether to apply it or not. I find that the court will not issue this sanction. In addition, the other sanctions the court stated earlier today, in addition, the court may impose the following remedial measures if warranted. Immediate suspension of video transmission of the hearing, with proceedings continue only on an audio-only basis for this proceeding where the violation occurred, and disqualification if necessary and narrowly tailored, of the news organization that filed the request in order for the electronic media coverage of the court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter where the court determines such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. The court also stated that before making a decision, it would allow counsel to make argument or statements, in which the court has done, and that the court's actions are not intended to have a chilling effect on the open and transparent courts or on responsible news gathering, and that the court is fully committed to the presumption of open proceedings under the applicable rules. That being stated, and as the court was listening, Mr. Burt has suggested that one of the potential sanctions is that for the camera for the remainder of the hearing, and not to show Mr. Robinson at all as a sanction for the remainder of today's hearing. And so the court considered that as well. This court does not wish to make a disproportionate decision on the actions, and it does note and does not minimize the violation. Therefore, this court will take up the suggestion by Mr. Burt that during the remainder of this hearing, that the camera shall not photograph Mr. Robinson at all, and that will be the sanction of this court. I will allow the pool camera operator to reposition the camera to adhere to that. Well, first, sir, I'm going to ask you to come forward because I want to make sure that's even a possibility. And again, I don't mean to put you on the spot. I'm simply, I don't want to set anyone up for failure. I don't want to make an order, and if it's not possible, then further sanctions could apply. And I recognize that it wasn't your anticipation to be on your own camera. But as it relates to not showing shots of Mr. Robinson for the remainder of this hearing, what are your thoughts?
I can do that. From where I'm positioned now, I can shoot this lectern, I can shoot the bench, and I can avoid the attorney tables altogether if that is what is desired.
All right. Do you need to do any repositioning of the camera to accomplish that? And I'm willing to give you that time to accommodate that. I just, again, I don't want to set you up for failure given what's happened. And so what are your thoughts?
No, I think the position I'm in, I am okay to avoid the attorney tables at this point and just shoot, this forward part of the courtroom.
All right. Thank you.
Thank you, sir.
All right. Turning to the parties, any clarification needed about the order of this court and the sanction that is imposed?
Your Honor, I only have one. It sounds like this issue is specific to video coverage and that the order not to take any imagery of Mr. Robinson would not apply, for example, to the still photographers. Do I have that correct?
Well, I'll hear from the parties before I offer that clarification. Do you wish to weigh in on that issue?
Just to indicate to the court that one of the problems is not just with the audio, with the video coverage, but most of the coverage is not covering the proceedings so much as close-ups of Mr. Robinson and comments about his demeanor. So if they catch him in a moment speaking civilly to his attorneys and he happens to smile, that then is twisted into evidence that he's some sort of a remorseless killer. So that applies to the still photography as much as what's going on with the video. So we'd ask the court not to permit still photography, at least for purposes of today. And I think after the court sees the motion, we'd be in a position to talk about the future. But I think for now, that's our request.
Thank you, Mr. Burt.
Thank you.
To the state.
Nothing further, Your Honor.
And any other inputs? All right. This court narrowly tailors its decision as to the violation, and the violation comes from the camera, the pool camera providing live feed. It doesn't come from the photographer. The photographer is the still, I don't know what the exact term is in this moment, it is eluding me, but the person who is operating the camera to take still shots is under the same requirements for this decorum order. I am not going to sanction them because what was before me with the 9-second clip and the 5-second clip doesn't apply to them. And so I'm going to limit the sanction as it relates to the pull camera photographer, again recognizing that the standing decorum order applies equally to the still camera photographer. Thank you, counsel. I appreciate you bringing this to the court's attention and the seriousness and professionalism that you presented this to the court. So thank you to all parties. And again, to the camera operator, do you need time to test out to ensure that there is any inadvertent capturing? I'm willing to do that. I just want to make it clear as day that Mr. Robinson is not to be captured in a sweeping shot in any form for the remainder of this hearing. All right. All right, counsel. With that in mind, how would you like to proceed?
Where is he? We'd ask the court to, and the clerk to swear in Mr. Gray.
Mr. Gray, if you would approach and stand before the court clerk to be sworn in.
You do solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. You can sit down.
Mr. Gray, if you'd like, have a seat. Usually we have water bottles. If not, there's one right here. All right. And Mr. Gray, I'm sure you've heard this before, but if you could position the microphones close to you, just to ensure that the record picks up your testimony today. Thank you. Mr. Novak.
May I proceed?
Yes.
Thank you, Your Honor. Mr. Gray, how long have you been associated with the Utah County State Attorney's Office?
3 years.
Okay, and was it 3 years ago that you were elected to be the chief prosecutor of that office?
Yes.
All right. And had you ever previously been associated with the Utah County Prosecutor's Office in any other capacity?
I've defended on criminal appeals. I was a criminal appeals attorney for the state of Utah for 23 years. So I represented the state of Utah on those criminal appeals, which would include Utah County.
Okay. And did you ever have any professional relationship with the Utah County Attorney's Office in any other capacity other than the appellate work you did before you were elected?
Not to my recollection, no.
Okay. Because we're in an open session and based on some of the guidance from the court, I'm going to ask you questions. Well, let me back up. How many prosecutors are in your office right now?
Well, that are with our courts, that are actively engaged in our court system is 30, and then we have screening prosecutors as well, and that would be another 7 or 8.
Okay, so I'm going to try to...
I should stop because I also, my executive team, they don't have courts, so there's another 5 of them as well.
Okay, so let me ask a better question. How many prosecutors in your office represent the state in felony matters?
Well, all of them that I just described.
30?
I mean, even the screeners. Yes, the screeners, my executive team, they are assigned to special cases. Usually my executive team, for example, aggravated murder cases, some homicide cases. So they also are prosecuting and represent the state in trials.
Can you explain what you mean by the executive team?
The executive team would include, obviously, myself. I have 2 chief deputies, one chief deputy, another chief deputy's general counsel, and then I have a division chief over
major crimes and a division chief over general crimes.
So is it fair to say that there are at least 24 prosecutors in your office who have substantial experience prosecuting serious offenses?
24. I don't know that I'd go as far as 24.
Okay.
Certainly all my SVU attorneys have that experience. Most of my violent felony attorneys have that experience too, but not all.
Okay. And do you know how many attorneys in your office have actually participated in homicide litigation?
I don't know the exact number, but I would say maybe 15.
Okay.
But I guess I should clarify, not all of them have the experience in aggravated murder cases, and that's why we specially assign those attorneys.
Understood. And how many do you believe have experience in aggravated homicide cases?
Probably 7 or 8.
And are all 7 or 8 assigned to this case?
No.
Are the 5 other than you who are assigned to this case experienced in aggravated felony cases?
4, well, either 3 or 4.
Of the 5?
Yeah.
Okay. All right, now I'm going to ask you some questions about a specific member of your office. And because the court may or may not ultimately order that attorney's identity remain sealed, you know what I mean by the word sealed, right?
Yes.
I'm going to refer to that person as Prosecutor A, okay? You all right with that?
Sure.
Okay. So how long have you known Prosecutor A?
About 3 years.
In your work as appellate counsel for the state, did you have any contact with Prosecutor A?
I may have. I don't recall. We generally send something out to, when we get an appeal, we generally send, the AG's office, we send something out to the prosecutor, ask them to fill out anything that we should know. More often than not, they never send us anything. And because it's an appeal, I mean, we're bound by the record. So there's not usually an occasion, but sometimes there is. But I couldn't say for sure that I've never talked. I certainly don't remember ever talking to him, though I could have.
Okay. Is Prosecutor A member of your executive team?
Yes.
Okay. And did you select Prosecutor A to be a member of your executive team?
Yes.
And that was at the beginning of your
Yes.
tenure as the Utah County Attorney?
Yes.
All right. And so you've had close working contact with Prosecutor A, who's a member of your executive team for the past 3 years?
Yes.
All right. And that, unless you're out of the office traveling or on vacation, that's basically every work day of the month, correct?
Yes.
All right. And have you met members of Prosecutor A's family? Ever? Let's just start with ever.
What's that?
Ever. Have you ever met members of Prosecutor A's family?
I have met his wife.
Okay.
I don't know if I've met his kids. I may have in passing, but I don't really. If I did, it was like at a function, they say, "This is my family," and introduce me. But I don't remember.
Have you socialized with Prosecutor A and his wife?
I think we went out to dinner once after a conference in St. George with some other prosecutors and their wives.
Okay. Have you ever been to Prosecutor A's home?
No.
Has Prosecutor A ever been to your home?
No.
You engage in recreational activities in any way with Prosecutor A?
No,
Whatever you do, running, pickleball?
no. I need to do more running, but unfortunately, I don't.
All right, understood. Okay, now, Prosecutor A has an adult child who was at the September 10th rally at Utah Valley University, correct?
That is what I mean, I don't have personal knowledge of that other than what they have told me. So like, I never saw that adult child, but I'm assuming, yes, that's true.
Okay, but on September 10th, 2025, at the moment that Mr. Kirk was shot and ultimately died from that shooting at Utah Valley University, you were in Davis County, right?
Yes, I indicated in the motion that it was Ogden, but it was actually Layton. So it was Layton,
Layton.
yes.
Okay.
And I think that's Davis County.
All right, that's what I thought. And Prosecutor A was with you?
Yes,
Okay, and isn't it true that while you and Prosecutor A were in Davis County, you learned from Prosecutor A that one of his adult children was at the rally and was texting him about their experience?
yes. I mean, we had just broken for lunch, and he showed me the text, Charlie Kirk got shot.
And that was a text that he showed you was from one of his children, right?
Yes,
And you knew at the time that it was a text from one of his children, right?
yes.
What did he say to you? So I'm talking about Prosecutor A.
He said, look at what my child just showed me. And that's about it. And then he said, I should be getting down to UVU.
Okay, and then he left.
Yes.
And he, as far as you understand, he drove down to UVU.
Well, he drove towards UVU, yeah.
Toward-
He drove in the area.
Okay.
Ultimately, I met him, and then we drove together to UVU.
Okay, so you, according to the pleading that you authored the pleading that was filed.
Yes, I did.
Okay, so that, for the court's benefit, that's the state's opposition to the motion to disqualify. You
Yes.
authored that, correct?
Yes.
All right. And in it, you said that 10 to 15 minutes after Prosecutor A left the event that you were at in Davis County, you left.
Yes,
Did you also head in the direction of UVU?
yes,
Okay, and then you and Prosecutor A met up somewhere?
yes.
And then traveled to UVU together in your vehicle or in Prosecutor A's? I guess there's a third alternative, which is you met somebody else and traveled with them.
No, I don't remember whose
Okay.
vehicle it was.
All right, did you talk to Prosecutor A?
It was my vehicle, I'm pretty sure.
Okay.
So,
And was that just about logistical convenience, like let's just go in one car, or was there
Yeah.
some specific reason?
yes, no, that was no other reason.
Okay. And on your way to that, what I'll call the meeting point, did you have any conversations by telephone with Prosecutor A?
Well, yeah, because we needed to meet. He left. I thought I would get some lunch first before I went to the command post. I got about halfway through that and said my mind was not on it. I needed to go to there. And so then we called. I believe I called him or he called. I'm not sure who called who, but then we met. We hadn't arranged that when he left.
Understood. But did he convey to you any more information about his child's experience in those conversations?
No,
Okay. And did you inquire, like, how's your kid or anything like that?
I did not.
Okay. And so you met up and then you went to the command post, which was established near the university, correct?
It was at the university.
Okay. Was it inside one of the buildings?
What's that?
It was inside one of the academic buildings.
Yes.
All right. And did you see Prosecutor A's child there when you were there?
No.
Were you introduced to that person?
No.
Okay. Did you have any conversations with Prosecutor A about whether they should stick around and wait?
No.
Did you?
My understanding, my understanding was that everybody had left. We were told that most of the students had left. They had not, or attendees, so.
Okay, so as far as you know, Prosecutor A's adult child had left the university before you arrived?
As far as I know, my understanding was that, most of the students had fled. That first they went into buildings or whatever, and then they made their way out.
You are aware, I'm sorry, that's not a question. Give me a second, Your Honor, if you would. Okay, so did you spend time with Prosecutor A at the command post on September 10th at UVU?
Yes, we were going different places, but there would be times that we would meet up. But off and on is all I can say.
Okay. And did there come a time, either on the 10th or shortly thereafter, where he provided you with some information about how his adult child was doing, having been at this rally?
I don't remember him ever saying anything about that, and I never asked. I probably should have, but I don't remember any conversation regarding his child.
Was there anybody else at the rally who you are friends with, or is a relative of yours, or a close coworker that you're aware of?
I know that there were some people in my LDS ward whose children were there.
Okay. And when you say some people, could you be a little more specific? Like how many different families?
Just members of the ward.
Sure, but do you know how many different families that would be?
I think I was told about 2.
Okay. And who told you that?
One of the families.
Okay, so one of the families in your ward informed you that one of their own children had been there, and then another one had been there?
And then somebody else from the ward had been there.
I see. And do you know who those people are by name? I'm not asking you their names. I just want to know if you came to learn who they are.
Yeah, I came to learn who they are. Yeah.
Okay. And are you close with those people?
We're casual friends with one of them. But I don't think I learned that until well after we had filed the information.
Understood. When did you learn that?
Sometime after. I don't know.
So the information was filed obviously in mid-September.
Just in 6 days, so.
Right. Okay. And do you know, like, if you saw the children of the families in your ward who you understood were there, if you saw them on the street, would you recognize them?
I would recognize at least one of them.
Okay. Did you ever have any conversations with them or their parents about their experience?
I tried to stay away from that, other than they told me that the one was doing just fine and the other one was shook up.
Okay. And the other one was shook up. Is that the term used, or is that just your way to summarize?
That's my way of summarizing.
What did they tell you?
Having a hard time with it or something of that nature.
I'm sorry I interrupted you. So somebody told you, somebody who you know from your ward,
Yeah.
told you that their child, is their child a student at UVU?
Probably. They're young adults, so I'm assuming that. I really don't know for sure. Yeah.
And I think what you said is that they told you that their child was having a hard time with it.
That not their child, but the other family's child.
Other family's child.
Yeah.
Okay, so it was like a secondhand thing.
Yeah.
Okay. And do you know if either of those young people who were at the rally, well, I'll put it this way, do you know where they were in terms of in what I'm going to refer to as the amphitheater
I
area?
have no clue.
The one who was having a hard time with it, did you share that information with the prosecution team?
I may have. I don't remember. I may have in passing.
Did you ever suggest to any of the law enforcement officers that that person be interviewed because they were impacted by what they experienced?
No. We don't interfere with the investigation. We try to assist. But law enforcement, they identify who they want to locate and who they need to interview, and I leave that to them.
Did the person giving you this information, so this is another adult in your ward, tell you more specifically about what their child and the other child actually saw and experienced?
No.
Okay, so you don't really know much more about where they were, what they saw. All you really know is one of them was having a hard time
Yeah.
with the experience that they had.
Yeah.
Okay. I understand you said that you don't interfere with law enforcement, but if you learn, even if it's somebody you know through your community, that somebody has suffered some emotional harm as a result of a criminal act that you are responsible for prosecuting, that's not information you would give to an investigator so that they could determine whether or not, so that they could go interview that person?
I didn't consider that as really relevant to the investigation, so no.
The fact that this young person was having a tough time with what they experienced is what you're saying isn't relevant? And when lawyers use the word relevant, we got to.
Well,
You know.
it's relevant to them. As far relevant as to our case, I don't believe so, no.
Okay, understood. Now, there was a point in time in October, I think it was October 20th, where Prosecutor A sent Mr. Robinson's counsel an email disclosing that his adult child had been at the rally, providing us with some information.
Yes.
And so my first question is, were you part of a decision to disclose that information?
Yes.
Okay. And were you part of a decision as to how that information would be disclosed or how much information would be disclosed? Like what led to that email?
Well, there was no decision needed as to how much. The decision was to provide the information that we ultimately provided you. And that is not because we believed that there was a conflict of interest, but that was out of an abundance of caution.
I understand it's your position that you don't think that there's a conflict of
Right.
interest.
But
I think that's clear. All right. Did the entire prosecution team, as it was constituted on October 20th, discuss this bundle of information that was being disclosed, or was it just you and Prosecutor A?
I know that me and Prosecutor A discussed it, and he may have discussed it with others. I don't believe anybody else was there.
When you discussed it?
When we discussed it, one of them may have been, or two, I don't know.
But the information that you obtained, sort of if I may, in the heat of the moment back on September 10th in Davis County, that Prosecutor A's child had this experience. And the text messages that went back and forth in the family, that information was shared with the prosecution team, correct? Everybody knew eventually.
Eventually.
Sure.
I mean, yeah, eventually.
Okay, so,
I mean, I only knew the fact that she was there. At the time, I only knew that she was there and that she left. That's all I knew.
Okay, but is it fair to say that you didn't set up any, but I'm going to use a term like firewall, to keep the rest of the prosecution team isolated from this information that one of their colleagues' children had this experience at UVU on September 10th?
No?
Is there a written policy in your office, either that existed when you arrived or that you've prepared since then, for how to evaluate whether one of your prosecutors needs to be screened off from a case?
You know, I'm not sure. I mean, we have those conflicts that come. I mean, the biggest thing on screening for us is if there's a potential conflict where information that the defendant has, one of our prosecutors has, because that's why you screen cases, is to make sure that shared confidences aren't also disclosed to, shared confidences with the defendant aren't shared with the prosecutor.
But you could agree with me that there are other types of conflicts that can arise other than what we might call the, privileged communication.
There may be. I mean, I think there can be. I can't think of any right now, but I think the rules are pretty clear with respect to shared confidences. You can't, screening isn't the end all, of how you treat conflicts. I mean, generally speaking, we will just conflict out to another office if we feel like we need to. One example, well, I won't go into that, but I mean, we've been threatened before, and there was an investigation, and of course, we conflicted it to a different prosecutor's office, because in that case, we were potential targets of this individual.
Understood. Okay, so you're not sure if there's a written screening protocol, but what you're saying is when we know it when we see it.
Well,
Sort of what I'm hearing you say.
sometimes we do. Sometimes I've had attorneys that felt like they couldn't talk after they've been conflicted out to at least know the victim, but notify the victim that that we were going to switch the prosecution. But there may be, I just honestly don't know. We keep an eye on those things and rely on our attorneys to notify us when there is a conflict.
But you knew as of September 10th that Prosecutor A's daughter attended the rally, correct? Was in the crowd, correct?
Yes.
Heard a shot fired, correct?
That, at that moment, I don't know that I knew that.
Okay, but you know it as of today.
Sure, I know
because
it
you
now.
read their affidavit,
Sure.
which says that.
Well, I knew it once all of that information was disclosed to me.
Okay. And that they had to, with many, many, many hundreds of other people, run for cover and get out of the open space where they were, correct?
Yeah, I don't know that they had to, but that's what they did.
Well, you've seen the video you've probably seen many videos of that
Right.
day, right?
Yes.
And weren't there law enforcement
Yes.
officers basically directing everybody to leave the open space so that they could
I don't
secure
know
it?
that I remember seeing those videos of the students or attendees leaving. I mean, I know that they left. I know that they ran away. What we learned later is that the shooter left immediately after the shot. So,
Right, but at the time of a shooting, you don't know
Sure.
how many shooters there are,
Absolutely,
if there's going to be
absolutely.
follow-up,
Right.
if there are explosive devices, like all those things, right?
sure.
Okay, so let me ask you these questions about, well, instead of giving you a headline, I'll just ask the question. Once you had all of the information about Prosecutor A's child's experience, okay? What they saw, what they heard, what happened to them, the fact that they were separated from their personal property, all those things, okay? What I'm hearing you say is you never really discussed that with Prosecutor A and his family.
No. I mean, I did discuss, I don't know if it was day 2 or day 3. Law enforcement was there on the day of the shooting, the next day, and I think into Thursday or Friday. I don't remember exactly which day. And at some point, I was told that Prosecutor A's child left the bag there.
Okay. But if you never really talked about it with Prosecutor A, about the impact on his child and the family.
I didn't say that. Not on the day of, or, I mean, in the intervening time, he reported a couple of times that he talked to his child and said that she was doing fine. She reported to him that she was not having any issues.
Did you ever ask him, well, what about you? I mean, your kid was at this.
I didn't. Not that I recall.
Did you ever consult with anybody in the Attorney General's office concerning whether Prosecutor A's child's experience raised a potential conflict of interest for your office?
No, that's what I did for 23 years with prosecutors, is consult on that. And so I didn't feel a need to go to those folks. I mean, I know how to try to figure that out.
So when one of your responsibilities in the Attorney General's office was to consult about ethical issues?
Different matters.
Different
matters. It could be a variety of things.
Okay.
And I mean, if you're talking about ethical issues in particular, I don't know that the Criminal Appeals Division was the right folks to consult, but I'm not even sure of who from the Attorney General's office would. So.
Okay, but you worked in the Attorney General's office for a couple decades, right?
Yeah.
And what you're saying is that in your role as an appellate lawyer for the state, you would talk to prosecutors, I guess it's somewhat more informally, about ethical issues.
Yeah, every once in a while, yeah.
Sure. And so my question is whether you reached out to anybody in the Attorney General's office about this particular issue.
No.
Okay. Did you, and when I say you, I really mean you or anybody in your office on your behalf.
Okay.
Okay? Because you're the chief prosecutor, right?
Yeah.
So when I say you, I
Yes.
mean you and
Okay.
and people who work for you. What about the Utah State Bar?
No.
I mean, they give ethics guidance to attorneys on all kinds of issues, right?
Yes.
Okay. But no
No.
reach out. Other county attorneys in Utah, in other words, your colleagues who are elected chief prosecutors in their counties, did you discuss this with any of them?
No.
Are you a member of organizations of what I'll call chief prosecutors?
I'm a member of the Utah County and District Attorneys Association,
Okay.
UCDAA. I'm actually the president of that organization. I'm a member of SWAP, which is the statewide association of public attorneys and prosecutors. I'm actually the president-elect of that organization. That's a lobbying organization.
Okay. And do these associations have any mechanism for providing ethical guidance to their members?
No. I mean, when we have questions, we may shoot out an email and ask about things.
Did you do that in this
No.
situation?
I consulted no one other than my team.
Okay. I'm going to ask you 3 more categories, just to be clear.
Okay.
Did you reach out to any law professors who
No.
purport to be ethics experts?
No.
Did you speak with any judicial officers
No.
about it? Court reporter, get the question and the answer? Oh, there you are.
Well, I just said that I have talked to
understand.
no one other than my team, so.
Okay. Did you ever discuss with Prosecutor A whether his child should or should not be interviewed by law enforcement?
No.
Are you aware of any?
Maybe, I don't remember. I'm,
Okay, so that may be important. You want to take a minute to think about that?
what's that?
That may be important. Would you like to take a moment to think about it?
I don't remember. I don't think so, but I do not remember.
The brief that you filed on behalf of the state, I'm sorry, the opposition to the motion has a couple affidavits attached to it, right?
Yes.
Okay. And one of those is the affidavit of Cole Christensen,
Yes.
and which for the court's benefit in the record is addendum C to the opposition. Special Agent Christensen writes in his affidavit that you and he, in mid-December, so that's after the motion to disqualify was filed,
Yes.
went to UVU and basically conducted some observations and measurements, right?
Yeah, he was investigating that part. I did go with him because it involved it doesn't involve trial. It's never going to come out in trial. So I did go there and assisted him. But he also had another officer there so that anything that I did could be corroborated by that officer.
Okay, but isn't it fair to say that basically what happened there is you said, generally, Mr. Robinson's defense counsel have filed this motion to disqualify. I want to have some measurements done because I want to figure out what risks there were to Prosecutor A's child based on where they were and where you believe the shooter was, right?
Yeah, we have very good evidence of where the shooter was.
Okay, so I want to,
And it was based on Prosecutor A's child indicated where the location that they were, I'll use they, and based on the evidence of where the shooter was. So we wanted to confirm that. Now they didn't know where, obviously where the shooter was, but we wanted to confirm based on, we knew where the shooter was, and so we wanted to confirm that that they weren't in the line of fire. And that was important because that's critical to the state's case, is whether or not someone's in the line of fire.
okay, so there's a few things there I want to try to make sure I cover. And if Your Honor, if there's any point in time where the court or its staff need a break, just tell me, because I can break whenever whenever the court needs that.
We'll be taking a break shortly, but I appreciate that, and if any of the parties do need a break, please indicate it as well. I want to be respectful to all parties.
Thank you. So the first thing I want to address, Mr. Gray, is that you knew that the defense had filed this motion to disqualify based on the relationship between Prosecutor A and somebody who was at the rally.
Yes.
And had the experiences that the court has already heard about. And so you basically went out with a law enforcement officer and you did an investigation and took a number of measurements.
He did, yes.
Okay, but at your direction, right? Because you're the one who
I
just-
asked him to do that, yes.
Okay. You say in connection with that there are some uncontested issues in this case.
Yes.
That's a term you used in your brief, right?
I'm sure that you will tell me where they're not contested, but.
Well, every issue is contested, right? I mean, the
So
state has-
is it, okay, go ahead.
I'm not trying to have a argument because the court reporter
Yeah.
doesn't like
I
when we
stopped,
speak over each
so
other.
I'm not.
And I'm bad at that too, and I have been for a very long time. But your measurements, as documented in Mr. Christensen's affidavit, Special Agent Christensen's affidavit, are of things that you say are uncontested. But I just want to make sure.
So can I clarify that? I never said that the measurements were not contested. I said what was not contested is the fact of the things that Child A could testify to. That's what I was referring to as what's not contested. Child A, as demonstrated in the affidavit, can testify that Child A was there, that Child A's location, and what the crowd did, what she did, and then what she ran in. That's what's uncontested.
But aren't these also uncontested things contested issues which you seem to suggest to the court are uncontested, and that is that the shooter was on the roof?
No, I didn't say that was uncontested. I said what she could testify to is uncontested. And if there was something different than that, that's certainly what I meant. I understand that all those other things could be contested.
Okay. You've made yourself a witness to evidence that you've used to try to advocate to the court that there's no conflict of interest, right? I mean, you basically, even though you're representing the state, you went out and you participated in a what you hope is a systematic way to measure whether Prosecutor A's daughter was in a line of sight from the place where the state alleges the shooter was, right?
Sure.
Okay.
But as far as making myself a witness, I was careful to make sure that there was Cole Christensen and then an officer from UVU. If you look at the case law says that prosecutors can participate in these interviews and so forth. What we do is make sure that someone else is there so that we don't have to testify. And the defense can't force the prosecutor to testify under those circumstances. That's the case law.
And it won't surprise you that competent defense counsel have the same practice. We don't interview witnesses without investigators present.
Right. And this was no different than that.
Okay, I do want to address another aspect of this line of fire situation, okay? So it's the state's theory of the case, if I may, that the shooter was on a rooftop, correct?
Yes,
Okay. And what's the name of the building that the state believes the shooter was on?
I don't recall.
Okay. And so these measurements that are in Special Agent Christensen's declaration, you're saying were designed to basically, if I may, I'm not trying to put words in your mouth, rule out whether the child of Prosecutor A is in some ways a victim of this incident?
Not as far as a victim. We already understood that, based on where the buildings were, that the child was not in that line of fire, but we wanted to provide the measurements for this motion.
So what is the significance of the measurement? What is the significance of whether the child of Prosecutor A was or was not in a physical position where they could have been shot? What is the significance of that?
The aggravator, as you know, is that we're alleging that when the shooter killed Charlie Kirk, that he placed others in grave risk of death.
And you've
So
now,
anybody within that zone, if you will, was placed in grave risk of death.
okay, and so you've now gone out and you've done these measurements from the place where you believe the shooter was, and anybody who's positioning at the rally, there's no line of sight. You're basically excluding all of those people from being among those referenced by that aggravator.
That's our understanding. We'd have a very difficult time proving that others beyond that point were also in that line of danger. I mean, we could, I guess, we could make the argument, but that would be difficult to prove.
And so is it your position that because this adult child would not fall within the category of people to whom the aggravator applies, there's no other connection between those people and the prosecution?
Not the crime. I mean, again, depending on whether, again, I rely on law enforcement to provide us with whether they have something helpful or not. We were able to determine based on what the prosecutor's child, there was nothing useful. There was no need to provide anything. I mean, we make those determinations when they provide it to us all the time.
Did you work with Special Agent Christensen on his declaration?
On what? No.
On his
no,
declaration?
I didn't.
Did somebody else?
Yes.
Another one of the members of your prosecution team?
Yes. That's generally the practice.
Okay. Was it Prosecutor A?
No.
Okay, now, we've also, I should say, you also filed with the court Addendum B to your opposition, which is the affidavit of the child of Prosecutor
Yes.
A, right? And this person is a young adult who is a student at the university, right, at UVU?
Yes.
Okay.
That's what I'm told.
Okay.
I have no reason
Did you
to doubt
speak
that.
with this adult child in connection with the preparation of their affidavit?
I did not.
Do you know who did?
I do.
Who was that?
It was Mr. McBride.
Okay. And do you know whether Mr. McBride consulted at all with Prosecutor A about that?
I couldn't answer that. I don't know.
Okay. Did you read the affidavit?
Of course, I wrote the opposition. I better read the affidavit.
Did you play any role in the shaping of the affidavit in any way?
No.
It was just given to you, here's the affidavit?
Well, I mean, we were aware of what the student, I'm going to call a student now.
It's fine.
We were aware with what the student had said as far as what the student was aware of. And so we obviously, as I started writing based on what my understanding of that was, and I'm sure that Mr. McBride covered those areas to make sure that we were accurate.
Are you saying that the affidavit followed from your briefing, and your briefing was based on your?
No, that's not it. My briefing was based on what the information that the student provided. And so to that extent, I'm sure when Mr. McBride talked to the student, that he would cover those things.
Okay, so what I'm missing is, where did you get the information about what the student experienced if
That
you
was
had not
from-
seen the affidavit?
That was from the prosecutor that is the parent of that.
Okay, so Prosecutor A told you, this is what happened with my kid.
Right, I mean, I think that's pretty established.
All right,
Okay.
Mr. Novak, this
Yes,
might
sir.
be a good time to take a brief break.
Whatever works for the
And,
court.
and just, not meaning to pressure you, I'm just trying to anticipate how much more time for questions you have for Mr. Gray, just for housekeeping purposes.
It's 4:06 according to this monitor. Oh, that's not right, it's 5 o'clock. The monitor says it's 4:06, that must be some time zone that somebody else lives in. At least another 20 minutes.
All right. So we'll take a 10 to 15-minute break, and perhaps council can confer in regards to housekeeping, how we wish to address the remainder of the witnesses, whether in a setting today or a different setting. I'm not saying which way, but if you wouldn't mind consulting, and we can discuss that briefly when the recess is over.
That's fine. Do you want to give us some guidance on what works for the court and its staff? Because, like, I didn't know it was 5 o'clock, but it is.
Right.